the hot topic of the hour, which is basically what is collusion and what is not collusion. Everyone really has been talking about, has been thinking about or calling me about whether they should file their H-1B this cap season or not. And then, so I think we should start off with, even before we start getting into, how to file a successful H1, how to tackle an RFE or avoid an RFE if we can, as to whether the H1 should be filed or not in the first place, and in which instances a H1 should be filed, and in which instance we should avoid filing simply because of the new H1B registration issues that we've had this year. So just to take a step back, USCIS received many registrations this year when compared to last year. It's almost double, 780,000, I believe. And out of that 780,000 registrations, there was about 400 plus duplicate registrations. So when I say duplicate registrations, we're really talking about the same beneficiary filing registrations through several companies. USCIS is aware of that. They sent out a report informing us how many registrations were duplicate and et cetera, et cetera. As a result of which, because they've realized there's so many duplicate registrations, they've also sent out a press report with reference to the fact that they think there are a lot of companies colluded to file registrations, and that is not allowed. So I think and so they plan to enforce that law with reference to collusion and go after some of the companies that have colluded. So let's talk about, because of this unique scenario, I think the number of duplicate registrations this year, the percentage of PICs has been very low. Usually it's about 20-30%. This year, the percentage of PICs has only been 7% because of all the duplicate filings. And as a result of which, USCIS is worried that their whole H-1B registration process may not be working. So they want to make sure that, the process works. And so they're trying to, enforce more, and so that, there's not that many duplicate registrations next year. So they're trying to seriously go after those employers who have done collusion. So what is collusion? I think we should start off with what is collusion, so we know, what is allowed within a duplicate registration scenario and what is not allowed. So when a group of companies, say, and this diagram will help, the group of companies, say employer 1, employer 2, employer 3, all of them together, they decide to file registrations for beneficiary 1, 2, and 3. So employer 1 has filed for the 3 beneficiaries, employer 2 has filed for the 3 beneficiaries, and employer 3 has also filed for the same 3 beneficiaries. I'm just giving an example. It could be 20 beneficiaries, it could be 30, it could be 3. In this case, USCIS calls this collusion because as per USCIS, if companies collude together to file registrations for the same beneficiary or set of beneficiaries with the sole purpose of increasing the chances of those beneficiaries getting picked in the lottery, then that is collusion. And USCIS announced in the beginning of the registration season that they are also going to put in an attestation, in which they did. So when you file the registration, you are signing off under the penalty of perjury that you're signing off on an attestation that you did not collude with any other employer to file multiple registrations for the same beneficiary through these different employers. So this is something that is not allowed. So any of you companies, if any of your, whether it be the employers or the employees, if this situation has occurred, then it is collusion, and I suggest that those employers don't file their H1, and I suggest that those employees don't allow the employers to file those H1s. So that's what collusion is, and that's not allowed. So let's go and see now what is not collusion, because of this whole thing. Let's go to the next screen, Michelle. Because of all this, there's been a lot of rumor and a lot of information that is being passed on as to what is collusion and what is not. So this is basically the language of what is the attestation language, is basically that I further certify that this registration or these registrations reflect a legitimate job offer. So that's the first attestation that you're making. And that I, or the organization on whose behalf this registration is being submitted, have not worked with or agreed to work with another registrant, petitioner, agent, or other individual or entity to submit a registration to unfairly increase chances of selection for the beneficiary or beneficiaries in the submission. So this is exactly what I explained. This is the attestation that you signed off on, but people didn't take it seriously, and they actually did commit collusion because they thought that it would not be possible for USCIS to actually find out that the companies were related. But what's happening is USCIS is not even bothering to look into whether companies are related or not. They're just, if they see a group of companies and they see there are several duplicate registrations within those group of companies, say company A, B, and C all have filed 30 registrations and all, and the 30 registrations all have the same list of beneficiaries, then they're presuming that it's collusions, and they send out an RFE or a notice of intent to revoke or deny, depending on in what instance they send it out. And they're saying that, look, all these are common beneficiaries. It can't just be coincident. It can't be an instance of coincidence. You guys must have colluded together. And then you have to show to the USCIS that there's been no collusion. So really, even if the companies are not related in any way, or they can't find a relationship, they're alleging collusion. In some instances, they're able to find a relationship in the companies. They're able to find bank information that's common. Maybe they're able to find office space that is being shared, or perhaps they're able to find a business relation, such as a petitioner, vendor, and a sub-vendor, client kind of relationship. So as I said, even in the instances that they don't find a relationship or they can't find one with the available public information, they're still alleging collusion, and then you have to show that it isn't. Next slide. So what is not collusion? So in not every instance, simply because there's a duplicate petition, it is collusion. So in this diagram that you see, that the beneficiary individually filed a H1 with employer 1, 2, and 3. And employer 1, 2, or 3 did not come together and decide to file a registration for the beneficiary. The beneficiary independently sought out employer 1, 2, and 3 and filed through those three companies. So if the beneficiary seeks out 3 different employers and files independently through 3 of them, then that's not collusion. It is not. So this is the most common misconception. A lot of beneficiaries don't want to file because most of them have filed through several companies, but this is allowed. That's why they did that. USCIS cannot prevent beneficiaries, or did not prevent beneficiaries from filing duplicate registrations. They only prevented employers from filing the same duplicate registrations for the same beneficiary and also colluding with other companies to file duplicate registrations through a group of companies. Okay, so independently beneficiaries finding employers and filing duplicates is allowed, no matter what you're hearing. Maybe there are some cases where USCIS has sent an RFE, but that is not against the law as per USCIS regulation. So even if they send an RFE, we can respond to it because they can't. They have to follow the law as well. Okay, so that's completely allowed. The other instance where duplicate filings are allowed is, say you have three companies. You own three companies. Joseph owns three companies, company A, company B, company C. And Joseph files a registration for John in all three companies. It is not collusion. It is not duplicate filings. If the job is different, meaning for company A, you have a job lined up for the beneficiary with AT&T. With company B, you have a job lined up with Citibank. With company C, you have a job lined up with Chase. So it's three different job offers. So that is not collusion and it is not duplicate filing. So that is allowed, and it has always been allowed by USCIS, as long as the job offer is different. So I hope that's clear as to what is collusion and what is not, and who can file a H1 and who cannot file a H1. I hope